Thank you for joining today's webinar, everyone. Today's program is entitled The FTC's Rulemaking on Non-Compete Agreements with Workers, What You Need to Know. My name's Gail Levine, and I'm a partner in Mayor Brown's Washington, D.C. office, where I co-lead the firm's global antitrust and competition practice. I joined Mayor Brown from the Federal Trade Commission about a year and a half ago, where I served as a deputy director in the Bureau of Competition. I'm joined today by my colleagues, Chris Leach and Nicole Saharsky, also from the Washington office. Chris is a partner in the litigation and dispute resolution and cybersecurity and data privacy practices. Like me, he's a former attorney with the Federal Trade Commission, he with the Division of Financial Practices. Nicole is the co-head of Mayor Brown's Supreme Court and appellate practice. She focuses her practice on briefing and arguing cases in the Supreme Court and in the federal and state appellate courts, and on developing legal strategies for trial courts and agency proceedings. Let me cover a couple of administrative matters and then we'll get started. First, this webinar is being recorded. In a day or so, we'll be sending you an email with a link, which you can use to listen to the webinar again or share with your colleagues. We're going to have that recording posted on our website. Second, we are going to try to allow time at the end of this program for your questions. To submit a question, all you have to do is use the Q&A widget at the bottom of your screen. If we don't get to your question during this webinar, we would be happy to follow up with you afterwards. So with that, let's get started. Slide, please. So the Federal Trade Commission proposed a new rule last month that would ban nearly all worker non-compete agreements nationwide. According to the FTC, the ban would increase workers' total earnings by something like $300 billion a year. It would also, according to the FTC, expand career opportunities for some 30 million Americans. The proposed rule has drawn sharp criticism from many quarters, including the dissenting Federal Trade Commission Commissioner Christine Wilson, who called the move a radical departure from hundreds of years of legal precedents. Next slide. So today we'd like to offer you a quick overview of the FTC's experience with non-compete agreements. Then I'm going to turn it over to Chris for an overview of the FTC's proposed rule. Nicole will then outline some of the possible legal challenges to the rule that the rule may face. And we'll close with some observations about what this means for your business. Next slide, please. So last month's proposed rulemaking by the Federal Trade Commission was not the first time that the FTC has engaged on non-compete agreements. In workshops and hearings and similar fora for about the last 5 years at least, the FTC has shown its interest in this issue. Last month, and I think it was about a day before it released the proposed rule that we're talking about today, the FTC announced that it had reached consent decrees with 3 companies settling allegations involving non-compete agreements. In each case, the consent decrees void the non-competes in question and ban similar non-competes for the next 20 years. So with that sense of the background of the FTC's interest in the question of non-compete clauses, let me turn it over to Chris now for an overview of the proposed rule, its scope, and what it would do.
Thanks so much, Gail. And that background overview, I think, was great because if you think of the FTC's focus on non-competes as sort of a little fleck of snow that started down the mountain, and now it's a big giant boulder because this rule that the FTC proposed on January 5 would, as Gail said, purport to invalidate and ban nearly all non-compete agreements between employers and workers. As Gail mentioned, this is a vote that had dissenting opinions. So this is done on a 3-1 party line vote, where all 3 Democrats, Chair Lena Khan, Commissioner Rebecca Slaughter, and Commissioner Alvaro Bedoya voted in favor of the proposal, with Christine Wilson, the lone Republican, dissenting. The rule, I'm going to go into sort of the ins and outs of sort of the main provisions, but one thing to keep in mind as we're going forward is that this rule would purport to preempt any less protective state law at issue. So if you think there's, I think, 47 states that permit worker non-compete agreements between workers and employers, under this rule, those laws would no longer have any effect, at least with respect to the actions here. The preemption provision does say that it would permit more restrictive laws. So a state that prevents a larger number of non-compete clauses or in greater circumstances would be allowed to keep going, but anything that is less protective of workers would not. The one thing, just if you want to know, one other thing is that comments are due on March 20th. So now, with all of those sort of big picture issues, we're going to get into the next slide with sort of the guts of the rule. So here, if you needed to know sort of 3 things about the rule, this is it. The ban on worker-employer non-compete. So there are 3 core requirements for employers to complete within 180 days of if the rule becomes finalized, at least under the proposed rule. One, the rule would prohibit all non-compete clauses in new contracts between an employer and a worker. Now, then that deals with contracts on a going forward basis. But what do you do with all of the contracts, the 30 million contracts that are in existence? The rule contemplates what to do with those as well. First, it would require a rescission of every single one of those contracts between an employer and a worker. And then the third requirement would require employers to provide notice to those employees. The proposed rule has some proposed language that employers could use to provide that notice, and has to be provided within a certain time frame. I believe it's in the 40-45 day range after the rescission happens. So those 3 obligations are what you could think of as collectively the ban on non-compete clauses. Now, to understand what that means in practice, this is like any good administrative rule, you got to go to the definitions. And so here, the 2 key definitions are worker and non-compete clause. And so if you look at worker, because here obviously this only applies in contracts between employers and workers, this is not just a standard employment law provision that only applies to employees. The concept of worker applies to any employee, independent contractor, or even unpaid workers. And there's no gradation between seniority. So this could apply, they say, to folks who are making sandwiches at a fast food sandwich shop, all the way up to CEOs of publicly traded companies, because even CEOs are employees of the company. Now, the second important concept is, what is a non-compete clause? Because that's obviously what you're not allowed to do. And here the FTC they've called it a functional definition of a non-compete clause. And it includes what we would always obviously think of as a non-compete clause, that you cannot work for another person in a certain thing for a certain time period. But they define it broadly as any contract, and I have the language up on the slide, any provision that has the effect of prohibiting the worker from seeking or accepting employment after the conclusion of the worker's employment. And so obviously for standard non-compete clauses, that we understand what that looks like, but the FTC takes the view that there could be other types of agreements that have a similar effect. And they provided 2 examples that I want to just highlight here. They talked about an overly broad non-disclosure agreement that in practice could prohibit a worker from seeking employment at another shop. And they cited, I believe, one California state court case that talked about a quote, an uncommonly broad or uncommonly restrictive non-disclosure agreement as being the functional equivalent of a non-compete. And then the second functional equivalent example they had was a punitive training repayment requirement. So, i.e., that if you go to a firm and you, instead of staying for 3 years, you only stay for 1 year, some companies might require repayment of training expenses. And so the FTC says, well, that might be okay, but if for example, you say that a worker, if you leave within 3 years, you have to pay me $1 million for training that only cost $500 to put on. That would be a functional equivalent of a non-compete clause. So those are not the only concepts that the FTC thinks could be the functional equivalent of non-competes, but for purposes of a rulemaking, we've provided those two examples. So I think those would be our touchstones for thinking about what is prohibited. So let's go to the next slide. So now we've talked about what the rule does, and I think it's helpful to understand why the FTC is doing this, because some of the decisions, particularly about senior executives, might be counterintuitive. So the FTC's justifications for this rule, I think, can be neatly sort of segregated into why non-senior executives, why senior executives, and then why is it okay to ban non-competes anyway. So with respect to non-senior executives, really just most sort of general junior employees, the concern is twofold. Sort of on the worker side, the FTC has the view that non-compete clauses are coercive to these junior employees, because they effectively don't have bargaining power either when they agree to the non-compete up front or when they're trying to leave the job on the back end. Now, then that's sort of from the worker side, but the FTC also takes the view that non-competes are harmful to competition more broadly, and specifically in the idea that it impedes it restricts the pool of available talent for other companies that are in these industries. Now, the considerations are very different when it comes to senior executives, and here think of your C-suite folks, or as I'll talk through later, really anybody who is something other than what we would call sort of a line worker. For those types of folks, the FTC, I think, it admittedly just doesn't have a concern that there is coercion involved or exploitation. I think the statement explains that quite often those folks have lawyers negotiating for them if they are sort of actual like senior executives being taken over, or just more broadly, these are folks who are highly compensated, for which you can view the extra compensation as the extra compensation compensating them for the restrictions in their employment moving forward. So that's not the issue. The issue for the FTC is on the competition side. Their concern is that incumbent firms essentially blocking the ability of their high-level employees to move between firms would restrict the ability of potential competitors, new entrants to the markets, obtaining talent either at all or obtaining talent at a reasonable cost, presumably because in order to justify payment, they might have to pay more to other folks it might cost more to search for firms, might cost them more to wait additional time before top talent is free from their non-compete, those sorts of things. That's actually one thing you can see in a lot of that sort of, I would say, echoes, and Gail can talk about this maybe a little bit later, but echoes some of their concern they had in the merger space, where you think of not just competition as it stands today, but this might impede potential competition from new entrants. And that's something that the commission's been very focused on in a lot of their merger enforcement work. So now the last sort of justification we're looking for is not sort of why the senior executives, why the junior folks, but sort of why they think that companies can protect themselves. Because as we all know, non-competes do serve valid purposes of trying to protect intellectual property and other sort of valid concerns. But the FTC's view is that the non-competes are essentially additional things that companies don't actually need in order to protect themselves. Here they point to two specific things, which I think will probably be the subject of many comments as to whether this does actually protect the same interest, but they point to the existence of non-disclosure agreements and trade secret law. Now, we're obviously familiar with non-disclosure agreements, and their view is that if a properly functioning non-disclosure agreement could protect the intellectual property or things like access to client lists, that that non-competes are intended to essentially be a prophylactic for. And then trade secret law, the that it just the general sort of Uniform Trade Secret Act that the FTC cites as being in most if not all states, the FTC's view is that adequately protects the intellectual property interests at issue. Now, the one thing I want to pause just to make an observation that I think is somewhat in tension with what we just talked about is that the FTC is highlighting the use of non-disclosure agreements as a way for employers to protect themselves. But if we look at what is the definition of a non-disclosure agreement, what's the definition of a non-compete agreement? They say that a too broad non-disclosure agreement could violate the rule. So here it sort of puts companies in a very tight bind where if you want to protect yourself, you have to rely on non-disclosure agreements, but it can't be too protective because then it might be a non-compete clause. So that's something that I would expect there's going to be comments about, and something that the FTC, if it ever proceeds to a final rule, is really going to have to explain, just because this is one area where I would say there's at the very least some tension, if not inconsistency. So if we go to the next slide. So now we've talked through the rule, which is no non-compete clauses between employers and workers. And it's pretty blanket, but there are a few carve-outs that I've talked about here. And obviously I'll jump to the second bullet because I feel like this is sort of just the flip side, which is that the rule only applies to agreements that are between an employer on the one hand and a worker on the other hand. So what that means is that it does not apply to agreements between businesses. So if you want to think about an M&A scenario where company A has a subsidiary in a certain line of business and wants to sell that subsidiary to another business, those two companies, at least under the rule, could have a non-compete agreement that would not be covered in that context. Now, that of course doesn't mean that those type of arrangements are free and clear from any regulatory scrutiny. The FTC makes very clear that regardless of the coverage of this particular rule, there could be issues that relate to other antitrust rules. For example, just the Sherman Act, that the Sherman Act could prohibit any agreement that restrains commerce. And so to the extent that these types of agreements are found by a regulator to restrain commerce, that would be a separate and independent concern that we might be able to talk about later. But that's one thing to keep in mind. So then the next concept that I'm going to talk about, and this is I'm just looking at the questions. There are a number of questions about M&A transactions, and that's a very good question because it previews one of the carve-outs here, and I'd say it's a partial carve-out. So the FTC recognizes, and this is similar to why agreements between businesses aren't covered. They recognize that when you are buying and selling a business or some sort of line of business, that the interests in preventing preventing competition between those entities makes a lot of sense, or it has very different interests than when you have them between an employer and a worker. So there is an M&A exception for the employer-worker non-compete prohibition. Just recall that in general, you cannot, under this rule, you could not have any non-compete agreement between an employer and a worker. This M&A exception has one relatively narrow exception. If somebody is selling a business who's, I'm calling them an owner worker, and I think here, just in your mind's eye, think like a founder of a startup who still owns 25% or more of the business. If that person then goes to work for the company, the purchaser, that person could be subject to a non-compete agreement under the rule, because that person would have had 25% or more of the equity in the business being sold. Now, what that means, however, is that if you're an owner worker underneath that threshold, then the rule would kick in and the company could not, the purchaser could not subject that person to a non-compete agreement. And obviously that's there's a bit of arbitrariness to that, because my understanding from talking to my M&A colleagues is that there are many circumstances that by the time a business is actually being sold in that context, where the founders are sort of selling their company to a larger enterprise, the founders have ended up diluting themselves to somewhere under 25%. So that's going to be a circumstance, I think, that has that a lot of my M&A colleagues have been focused on, and I think folks are appropriately questioning whether that's the right line or if there's some other way of addressing this issue that would be more appropriate. Now, while we're on the topic of this M&A exception, I do want to note that there's there is a I'd say an odd quirk of drafting in here that I just want to flag for folks. So recall that this only applies to agreements between a worker and an employer. But in the buyout scenario, what happens if this this owner worker who has 15% of the company is not going to go work for that company, but is rather just going to buy out and leave, such that the non-compete agreement is never with that worker and his or her employer? I think that my guess is that the FTC might not have intended that the rule would allow a non-compete in that circumstance, but just by the terms of the rule, it would seem likely, and I mean, we would have arguments that that would be totally that would be allowed within the context of the rule. So that's one thing just to keep in mind, that if folks have questions regarding the M&A context, I would say so do I. So I think that's something that hopefully will get resolved if the rule ever takes effect. Now, the other carve out I think that's the most important to keep in mind is the most important thing to keep in mind in terms of carve out is that because it's the Federal Trade Commission, this rule will only apply to companies that are subject to FTC jurisdiction. So although the FTC's jurisdiction is broad, it applies to literally any act or practice in commerce. It has several exemptions for certain types of companies, and these can end up being like rather large hunks of the economy. So for example, the FTC does not have jurisdiction over banks. That's defined generally as, think of any OCC bank or FDIC insured bank, and there's other nuances there. The other exemption are air carriers and also common carriers. And the FTC takes at times a sort of fine-diced approach that, for example, for common carriers, their view is that this only applies to a company with respect to its actual common carrier exceptions. It's not if you have a common carrier function that you are by definition a common carrier. A lot of telecommunications firms have had this issue, and there have been some circuit court decisions on that on point. So that's just one thing to keep in mind if you're sort of thinking through, does this actually cover my business? Now, the last point, just an exemption, is something that, again, this is part of their definitions. They exempt non-competes between a franchisor and a franchisee, which I think probably makes a lot of sense, because if you have a franchisor trying to have contracts with individual franchisees in different jurisdictions, you're going to want to make sure, one, that a franchisee is not having competing franchises competing with other franchises to try and sort of cannibalize your own business. So that's something that is totally exempted, but keep in mind those types of agreements could be subject to the FTC's franchise rule or other principles of antitrust enforcement. So that's I think I see one. Can their relationship follow them? Sorry, I'm looking at a question that's talking about a specific instance about somebody wanting to change employers. Can their relationships follow them? I think the answer, I'm not quite sure I understand what the question is, but I think the idea here is that businesses, if they want to protect some of their interests that would normally be protected by non-compete clauses, what they would want to do is make sure they have other types of contract. So I mean, I think they did talk about non-solicitation agreements as being okay. That you're not allowed to solicit your old clients or old employees, but that there might be other concerns within them. But just for the purpose of this one rule, it only would apply to the non-compete agreements. Although I will say, obviously, that given that the FTC has said that this has a functional definition of a non-compete, that I would say we can guess at how the FTC might decide to interpret that functional and broad definition in the future, but it seems like they're not making too many commitments not to adopt a particular more restrictive definition in the future just by in the course of their enforcement.
Chris,
Sorry,
can I
Gail.
ask you a question implied
Sure.
by the question that we've gotten from that listener? That might shed a lot of light on this. The questioner asked exactly as you said, what happens when you change, if a senior executive is changing employer, can their relationships follow them? And then the question said, assume the person who's moving has a less than 10% ownership stake, right? Or had before he left at least. I think that question is conflating two concepts, one about non-competes and one about the M&A 25% rule.
Yeah.
Can you sort of untangle that and help explain how those are really two independent prongs?
Sure, that's totally right, Gail. So the I think if you want to think about the first part, which is the restrictions on a leaving partner in that context, that would all depend on looking at analyzing, is this a non-compete clause? And obviously you just have to think about, does this prohibit the person from seeking employment in the future? And there's and I don't think we are going to be in a position to answer that question here and now, whether this particular type of restriction does, but that would be how we would analyze that. And then the separate point is looking at the sale of a business. And I think that if the I guess in the sale of a business, my guess is that, like, I think the FTC frankly is thinking that a doctor who is selling his practice to another doctor, a younger doctor, like that type of thing is probably okay within the concept of their proposed, what they're trying to do. Whether it falls within the four corners of this exception, I think just has to do with some of the ambiguities in the ambiguities in the drafting. So that's how I would analyze that issue. Whether we have an answer or not, I think will depend largely on what the final rule says, because of all of the parts, I would expect this to change, to be one of the parts that gets tweaked, just because one of the 25% line, and then the actual workings of how this applies to either employees that are not going to be joining a new company, et cetera.
Thanks.
So if we go to the next slide. So as I said, this is the FTC is contemplating changes to the rule in response to comments. And what they did was they did flag a couple of alternatives that they were thinking through if they were going to draft a different rule. So right now, and the way that I would think about this is that their main alternatives are on two different axes. One is what types of workers the rule applies to, and on the other axis is how does the ban or not ban apply. So on the types of workers, right now it's sort of, they have the rule applies uniformly to all types of workers, but they've recognized that there are differences in different levels of employees where there are, I would say, fewer concerns with non-competes the higher up the ladder you go. And one of the things they're thinking about is, well, how would they define that? They talked about three different alternatives here. One would be job function, really just saying, are you a chief something? Are you a C-suite person, or some sort of very clearly defined band that would be very easy to know up front? A second proposal they talked about were FLSA exemptions. And I think my guess is that the FTC looked at the FLSA exemptions as something that most companies are familiar with. So it would be, if not easy to apply, more familiar to apply than some new distinction. And then finally, an earnings threshold, just on the similar to sort of some of the rules that the Securities and Exchange Commission has for qualified investors, under the theory that anybody who makes above a certain amount of money can protect themselves. And so that's sort of the different ways that they're thinking about defining a worker threshold. And I think that if there are other ways of defining worker thresholds, they're open to that. This is just sort of what they in their process had come to as sort of I'd say the buckets other than apply to all the same way. So then on that other axis, the operation of the ban on non-competes, they proposed really three different options. One is the total ban, which is what they have right here, where there are other than the few exceptions, like if the rule applies, it is a ban, full stop, which the FTC has the benefit of certainty in that there doesn't need to be sort of an extended litigation period. Sort of, if you just look, is there a non-compete? And if so, then it is unlawful if it's covered by the rule. The other, I'd say the other proposal they talked about is a rebuttable presumption, either in saying a non-compete could be allowed, or a rebuttable presumption prohibiting a non-compete unless certain circumstances apply. And here they've talked about this really mostly in the context of for the senior executives, like for example, and this is where I have on the bottom, potentially, and they've said that they've thought about mixing and matching different approaches. So having different job functions with different types of operation of the ban apply. So for example, the FTC floated one potential combination as a total ban on non-competes for non-executives, but a rebuttable presumption prohibiting non-competes for senior executives that would allow some sort of proof by an agency, I guess, in the event that they're sued or something like that, to allow the non-compete to proceed in that way. So those are the types of alternatives. And obviously that we're going to talk about the fact that they're taking comments, but these are the types of things that the agency's already thinking about. So if folks have, if there are companies that are contemplating comments, these are some of the areas that the agency's already thinking of, and so could be an area that to push the agency if you think it would be helpful. Now, if we go to the next slide, this is just the process, and this will be quick. So the next step in the process, and this is something that was actually recently announced, is that on February 16th, the FTC is going to hold a public forum on the proposed rule. And this is standard fare now. Whenever the FTC has a big rule, shortly after it, they have they might have several public events. And this one is going to have workers who are subject to non-competes and businesses who have experience with non-compete clauses, followed by probably 2-ish minute web opportunities for folks from the public to talk about their experiences or their views on the proposed rule. And that's going to be a 3-hour event from noon to 3, and that'll be webcast. In terms of the next steps, comments are due, as I said, on March 20th. 2023, there's already been a substantial number. I think when I checked earlier this week, it was more than 5,000. I apologize if it's now more than 6,000. But that date, I think right now is set in stone, but for many big rules, you often have companies that are file petitions to extend the time for rulemaking. I would, if that hasn't happened already, my guess is that will happen here, and you just have to look to see what they do. Sometimes the FTC grants, sometimes they don't. And now, one thing to note here is that unlike some of the other rulemakings you might be familiar with, like for example, the commercial surveillance rulemaking, this comment period is going to be the only opportunity for the public to comment. So this might be something that I think Nicole might address a little bit in the next, but for the FTC's consumer protection rulemaking, there's a much more expansive process regarding an advance notice of proposed rulemaking, then the proposed rule with comment, and then an opportunity for interested parties to question the FTC's evidence during a contested rulemaking. That is not here because of the particular type of authority that the FTC is purporting to rely on here. So I think I'm just flagging this because if companies are interested in sharing their views, or if individuals are interested in sharing their views, this is really the only time to do it during this process. So with that, and when I say this process, I mean before there's any finalized rule and everybody gets to sue everybody else. And so for the possible legal challenges, I'm going to turn to Nicole, who's going to cover some of the, on the next slide, some of the areas that folks might be looking at on this front.
Hello, everyone. So as Chris previewed, everyone's going to sue everyone else. That's going to happen, assuming that a rule gets finalized. And it sure seems like the agency is heading in that direction. And so I think there's a question of, who will bring those challenges and when, but in terms of some of the significant industry groups, folks like the Chamber of Commerce, other groups that you all might be involved in, I would ask those groups what their plans are, and I would bet that they're watching this pretty closely. In terms of potential legal challenges, so this is an administrative agency action. And so the way to challenge it is through the Administrative Procedure Act. And there are, it has to be the final rule. We can't do anything now about the proposed rule. It has to actually be the final decision of the agency about how it wants to go forward. And there are going to be a number of legal arguments that are potentially available, including that what the FTC wants to do here goes beyond the statutory authority that it has, that Congress gave it. That it has potentially has a constitutional problem, or that it's just arbitrary and capricious in that the lines that it draws and the decisions that it makes just don't make sense, even that they're not reasonable. In terms of how this might proceed, we think the lawsuit would be filed in federal district court. You may be familiar with administrative agency proceedings where the agency issues a final decision and then you file a petition for review in a court of appeals. But here, the statute that allows jurisdiction for review in the Court of Appeals is limited. That's in Section 18 listed here to cease and desist orders. So this would be a district court action, and it would be judged based on the administrative record. The reason that we note that it would be based on the administrative record is because to highlight that comments are so important to this process. I think Chris gave a sense of having the opportunity to weigh in and to tell the FTC what it's doing here doesn't make sense in some respect. And the way to do that is to get that on the administrative record, because once you go to court to challenge it, it is much harder to bring those things into the fold. So let's get more specific about some of the arguments on the next slide. And I should say, many of these arguments, to the extent you want to read more about this, are set out in Commissioner Wilson's dissenting views on the proposed rule. It's really beautifully written, honestly, and has a good synopsis of these arguments. And so I would definitely recommend it. It's not lengthy and it's very common sense and provides good background. So first would be potentially that the FTC just doesn't have the authority to do what it wants to do. And so what you do for this argument is to look to the statutes that set out the FTC's authority and the statutes that it's relying on here and see, do they give it the authority to issue a broad rule like this? And so the FTC here is relying on Section 6G of the FTC Act. And it has, pretty broad language. You see it up there about making rules and regulations for the purposes of carrying out the provisions of this subchapter. So that, by its face, it looks pretty broad. But there's actually a whole bunch of history here that really questions whether this section 6G, can be used for a substantive rulemaking on competition. And so there's a long history of the FTC treating it as providing only authority to make procedural rules. And then in the 1960s and 70s, there was kind of a limited attempt to make substantive rules on competition. One of them was withdrawn. The other one was challenged in court. There's an old DC Circuit decision, this National Petroleum Refiners, that upheld the substantive rulemaking authority, but the method of analysis is just not necessarily something that the DC Circuit or other courts would agree with today. It has a lot of legislative history and just a very 1970s way of looking at things. I don't know how else to say it other than that I would not put all my eggs in this DC Circuit decision basket, thinking that there's sufficient authority for the FTC to use Section G here. And then I think the interesting thing is that later in the 1970s, this Magnuson-Moss Act more specifically codified the FTC's power to issue substantive rules on consumer protection, but pretty conspicuously did not put in a power for the FTC to promulgate substantive competition rules. And so there's kind of a question there. If Congress only gave the more specific power about one, does it intend for the FTC to have this power with respect to the other? I mean, you look at the language, on the one hand, it's pretty broad, but this kind of history and the more specific language in the Magnuson-Moss Act suggests that you could bring a pretty decent challenge to this to suggest that Congress did not intend to give this kind of authority to the agency. So that's the first thing to think about. If we go to the next slide, we'll give another kind of point to think about. This is where we just go right into constitutional law. So the Supreme Court in recent years, I think everyone probably knows this, has been pretty harsh on administrative agencies. Especially the more conservative justices have articulated a lot of concerns about administrative agencies wielding too much power and not being sufficiently checked by the president or sufficiently delegated the authority that they need by Congress. And so the way that the Supreme Court has kind of put out its views in recent years has been through a couple of doctrines. The first is the major questions doctrine. This is one that I didn't learn about in law school because it was essentially like made up by the Supreme Court in the last couple of years, but it is definitely the law of the land now. And there was this decision last term in West Virginia versus EPA, where the EPA was trying to assert pretty broad authority to regulate stationary sources. These are like smokestacks and the like. And it was so broad that it would really require like what is called generation shifting. So not just making the existing smokestacks better, but to require some of the companies to invest in renewable energy and new sources of fuel. And going to the Supreme Court, the challenger said this would have such a huge impact on the US economy. Like, don't we have to be sure that Congress really meant to give the EPA that authority before the EPA has that authority? And so the Supreme Court articulated in that case what it called the major questions doctrine. And it said that Congress has to be super clear when the issue or the question is one that affects, has great economic and political significance. And so there's some, suggestion as to what is a major question. There's this language that we have quoted up here. We focused on economic and political significance, the history and the breadth of the authority the agency has asserted, if this is a change in agency position, et cetera. But it's basically a thumb on the scales that if what an administrative agency wants to do just seems super broad, particularly in terms of its effect on the US economy, that the Supreme Court has suggested that unless Congress gives that power, the agency doesn't have the power. So just think of this as like a statutory interpretation analysis. Like the way I learned statutory interpretation in law school is, you look at the text of the statute and maybe the broader context, the purposes, the legislative history, et cetera. And so here in the EPA case, and it also would be the case here for the FTC, a court would have to figure out, like, does the agency have the power to do this thing? And instead of just going through that analysis and trying to look at all those sources of text and context and history, the agency would basically face like a thumb on the scales against it from the beginning, that unless Congress was super clear, like a clear statement rule, then it would not have the authority. So the major questions doctrine, I think, is still being figured out in the lower courts because the Supreme Court has only recently articulated it. But certainly, like Commissioner Wilson, the dissenting commissioner here, picked up on it right away that would be something that could be used to call this potential new rule into question. She says the FTC hasn't really asserted the authority to make these substantive competition rules. The economic effect would be massive. And then you'd also have this existing effect on state law. So a pretty significant effect. So, I mean, my view is that whoever's going to bring a lawsuit on this is almost certainly going to raise a major questions doctrine question. And then the next slide, it's kind of a similar idea to the major questions, but a little different. And this is something the Supreme Court has expressed interest in kind of revitalizing, but it hasn't really issued decisions as recently. So the non-delegation doctrine is a separation of powers doctrine, which basically looks to how Congress interacts with administrative agencies. And in particular says, if Congress wants to give administrative agencies part of its power, the legislative power, it has to set out some rules by which they're going to exercise the power. And so in the past, the Supreme Court says that Congress has to set out an intelligible principle in the statute where it gives the administrative agency the power to provide sufficient guidance and limits. And so in the past, there was an old decision that you might know about, Schechter Poultry, where the Supreme Court struck down FTC rules that were basically broad rules that the Supreme Court called codes of fair competition, suggesting that perhaps there wasn't sufficient guidance from Congress. And in recent years, the Supreme Court has been poised to really strengthen, I think, the non-delegation doctrine, potentially to say that, there even needs to be more than an intelligible principle, more guidance, more limits from Congress before giving power to an administrative agency. So if you think about this, if you think about the kind of arguments that I've talked about so far, you have this question from the beginning, which is like, does the administrative agency have the power to do it under the statute, which it may or may not have. But if you get past that hurdle, you may have this other problem that like if Congress delegated that much power, maybe it didn't do it clearly enough. So it just seems like one way or another, this is going to be a pretty tricky situation for the FTC to be navigating in court. And then I think there's just one other slide on legal challenges, which are, arbitrary and capricious challenges. So this is the kind of thing that's normally addressed when someone challenges an administrative rule. Arbitrary and capricious is not a super easy standard to meet if you're the challenger. It doesn't have to be that the FTC or any agency adopted the best possible rule, but it does have to be a rule that kind of makes some amount of sense and that kind of that has some justifications actually in the administrative agency record. And so I think there will be questions as to what the best arbitrary and capricious challenges are, and those will depend on how the administrative record looks when the FTC gets to the point of promulgating a final rule. But things to look out for, some of which I think Chris previewed a little bit. One, how well the agency addresses the concerns that commenters put in, how well it explains where it drew different lines, for example, the 25% threshold, and then whether there were alternative approaches suggested that kind of better protect some of the interests that the FTC says it's trying to protect. Now, this is arbitrary and capricious, so the FTC does not have to pick the absolute best option, but it does have to justify its option, and that justification has to be in the record. And so as this proceeds, I think that shows how important it is to provide feedback and to provide comments, because it puts that burden on the agency to justify. And then, B, once a final rule comes out, we'll be able to look at that record and really see where there are potentially some holes or some places where this might be susceptible to challenge. So I think we're moving on to Gail for the next slide.
Okay. So there was a question in the chat earlier about the timing here. So let me speak to that a little bit as I jump into this slide. At this point, the FTC rules, the FTC is going to be receiving comments from the public over the next month or so. The FTC at that point is going to have to evaluate what the shape of its final rule is going to look like. And once it releases its final rule, if it releases its final rule, as Nicole has said, it would not at all be surprising if that rule were challenged in court on the grounds that Nicole has already outlined. If a court rules against the FTC, the rule could be enjoined, and that's our time. That's what you need to know in terms of timing. Oh, and by the way, one other thing, the FTC has announced that it will give companies 180 days after the rule is finally promulgated to get into compliance with the rule. Another point to know when you're thinking about timing. But let's assume for a moment that the rule isn't in place or that the rule gets enjoined or whatever. It doesn't mean, even if that's true, that doesn't necessarily mean that the FTC will cede the field. Like we were talking about earlier, the FTC has brought enforcement actions in this space. Enforcement actions at the Federal Trade Commission are quite independent of this proposed rule. Indeed, I think the enforcement actions were announced by the FTC before the FTC even made public that it was going to propose a rulemaking here. So with that in mind, maybe next slide, please. I want to go through some sort of practical tips that you might think about at your entities, your companies, your places of employment, to think about in terms of minimizing the chances of an FTC challenge on this issue. So first, consider ensuring that your non-compete agreements are designed to protect legitimate business interests. Think protecting trade secrets, think, protecting confidential, proprietary information, things like that. Also, take an eye toward your non-compete agreements to think, okay, are they narrowly tailored to do what we need them to do? Are they long enough to protect the legitimate business interests at stake, or are they longer than you need? The FTC's 3 enforcement actions that it brought last month in this space, all challenge agreements that lasted, I think, a year or more. And then ask the same questions for geographic scope, for industry scope. Is the scope of the non-compete broad enough to capture all of the things that need to be protected and not significantly broader than that? Asking questions like that will at least mitigate the risk or minimize the risk of an FTC challenge, quite apart from this rulemaking when it becomes finalized. A a pitch and sneak preview from the Mayor Brown team. Our employment group is going to be presenting a webinar like this, but that's going to be focusing on very practical employment and executive compensation issues that arise in connection with the FTC's proposed rule. So please do keep an eye out for that kind of invitation soon. Next slide. All right, so at this point, I think I'd like to dive into some of the questions that we've seen in the chat. If you have additional questions, this is a good time to continue adding them to the chat. We're monitoring it in real time. All right, so one question I see, and Chris, I'll invite you to speak to some of the questions, in just a second. One question I see as a theme running through many of the questions we've received during this hour is asking about things like LTIs, whether the employees that the proposed FTC rule would unburden of non-competes has, in a sense, already sort of gotten compensated for and is being paid for the agreement not to compete, such that there's really very little hardship on the employee. That's sort of the instinct behind many of the questions we've seen in the chat so far. And I guess one sort of observation in response to that theme would be to say that the FTC's notice of proposed rulemaking focuses on hardship to the employee when it comes to certain low-wage employees. I don't know that there's ever a cutoff or a dollar amount, but those kinds of employees generally. The FTC talks about the coercive nature of non-compete agreements with respect to those kinds of employees. With respect to other more senior employees, the FTC focuses on a different/additional harm, which would be the effect of competition in the market for the products and services generally, not so much on the labor market, but on the products and services, is tying up talents, hurting entry in the product or services market more broadly. That's the kind of question the FTC is asking when it's thinking about weighing down senior executives, freeing senior executives from non-competes. Chris, can I turn to you to see if you want to pick up on any of the questions you've seen in the chat?
Yeah, sure. I think one commenter asked about no poach agreements, which the rule actually does, the discussion prior antecedent to the rule, its proposed rule itself does talk about no poaches, or at least refers to no poaches. And I think the way you'd want to analyze this, I think first at the outset, is that whether the type of a no poach agreement would actually cover the rule itself, because that's obviously a no poach agreement would be Gail and I are in a business together. I want to leave, and as part of me leaving, Gail, because she has more power in the relationship, says, Chris, you must sign a no poach agreement. That does not technically prohibit me from seeking further employment, like on its face. So just, would that be a non-compete clause in a traditional sense? I think the answer is no, because it frankly restricts the type of employment it really restricts, are the employment moves of more junior employees who we would be poaching. Or then I guess the no poach also could be client agreements too. But so I guess the idea is that the no poach agreement could be viewed by the FTC as the functional equivalent of a non-compete if it goes beyond the FTC sort of, think of like Plato's chair in the sky, like their chair in the sky of what a normal no poach agreement is. And I think, and I'm being a little glib when I say the Platonic ideal of this, but I mean, right now, these are very vague concepts, and I'm not even sure the FTC has a concrete understanding of sort of where even generically its line would be between a valid no poach agreement and a no poach agreement that materially restricts the ability for a person to get future employment after a deal. So I think that I apologize if I'm not able to sort of give you a like four square concrete real answer to that, but that's, I think, sort of the best we can do right now, just given what we have with the rule.
And Chris, can I just add on to that? one of the challenges of speaking in a webinar like this is just semantics, right? So sometimes people are using one phrase when they mean some other concept. Often when people are using the phrase no poach, if they're not talking about what Chris was describing, they sometimes mean, say, an agreement between two rival companies where their senior folks get together and they say, I promise not to hire the folks from your team and you promise not to hire the folks from my team, or something like that. Or we promise not to go after the same candidate. That's what sometimes referred to as a no poach agreement. And DOJ has brought cases in that space recently. DOJ antitrust enforcement has brought cases in that space recently.
Got it. So now there's another good question from another anonymous attendee. I wonder if it's the same anonymous attendee. But so there's another question from anonymous attendee about compliance. And the question reads, if the rule becomes final and the company has non-competes in place, what are the options to get in compliance? And if the company decides existing agreements are too broad, do they all need to be officially withdrawn? I think the answer is just sort of first step. Obviously, like what is a non-compete could change between now and a final rule, but assuming we have the final rule, if the company determines that if it is a straight up non-compete clause, then I think the rule says that would need to be rescinded and with notice given to the employee. So a rescission would just be the company considers the contract provision null and void. And then the second step is to inform the employees that they have considered this one contract provision to be null and void. And so that is sort of baseline what needs to happen. If there are other provisions, because obviously with this functional equivalent thing, I think it's going to require companies to really take a comprehensive look at what they're doing in their agreements with employees in this space and get comfortable with, well, is this really a non-disclosure agreement, or is this a secret sub rosa non-compete clause? And for those types of agreements where it's not actually a non-compete, but it might just be too aggressive for what we think to be the FTC's taste, that would be something where the company might need to just consider having new agreements, sort of rescinding the old agreement that they don't think is compliant and having employees agree to new non-competes. And obviously that's something you need to work out with your employment, your HR and employment counsel, but just from a functional standpoint of complying with the FTC rule, I think that would be what the expectation is. I don't know if Gail, if you have a different view.
Well, I think in our last 3 minutes left, we should probably tackle the latest question, which is about independent contractors. Chris, do you want to speak to how the FTC includes the term independent contractors in the definition of workers?
Sure, in that this is actually a great question to end with because it's very easy. An independent contractor is a worker under the rule. So the term worker is extremely broad, and it's intentionally broader than the concept of an employer-employee relationship. So things like gig economy workers, really anybody that does things for you, including people who are not getting paid. So like, I guess this would be unpaid interns there, or people who are just volunteering their time. All of those people, including independent contractors, would be subject to the prohibition on worker-employer non-compete clauses. So I think that's it, Gail. I'll let you wrap up.
Well, sure. I'll wrap up, not for lack of questions outstanding, but for lack of time. We'll do what we can to reach out to each of you who have asked a question. If we can get back to you with that, we're happy to answer any questions you have. But for now, that wraps up today's program. And on behalf of Mayor Brown and my colleagues, thanks very much for attending. That concludes our webinar. Thanks for your time.